examiners for August the 23rd. Kim, would you please take the roll?
Sure. Esther Lynn.
Present.
Angeli Agatev. James Bolton. Robert Brody. Alex Chan. James Afting. Judy Gillespie. Karim Gongara. Dolores Heisinger. Michael Iseri. Larry Kaplan. Paul Kramer. Alex Lawrence. Bethany Pick. Vince Reyes. Shelley Torriaba. David Torres. Patricia Villalobos. And Chair James Fox.
Present. Thank you. The next item on the agenda is to call for public comment. Is there any member of the audience who wishes to address the committee? Yes, come on up, please. And is there a microphone there?
Yes, right on. There we go. All right. Thank you. My name is Tim Weimer. I'm the interim dean for San Francisco Law School. We do have an item on the agenda today in relation to our move to a new campus. I just wanted to introduce myself and let you know I'm here to answer any questions you may have when that item does come up.
Okay, thank you very much. Are there any other public comments? So we're going to for logistical reasons, we're going to go off schedule with the agenda, but the next item we're going to call is item E, the approval of the June 21st Committee of Bar Examiners public meeting minutes. You have received a copy. Are there any corrections or changes that anybody wishes to make? If not, is there a motion? Yes, Robbie.
Move to approve the minutes.
Second.
Motion and a second. Any discussion? If not, all in favor, say aye.
Aye.
Opposed? Abstentions?
Just me, because I wasn't there.
Okay, thank you very much. Okay, next item is a report from the director. First is on the key statistical indicators for May and June.
Good morning. We have attached the key statistical indicators for May and June in attachment 101. One of the requests that we had received a few meetings ago was to include the numbers for the Law Office Study Program, and they've been incorporated in these statistics. So a few things to note in terms of trends. Some of the highlights is that we have experienced a decrease in certain applications. I just want to point out the ones that have greater than 10% of a decrease. First would include the attorney's bar exam. Again, these are attorney applicants for the bar exam, so that makes these attorneys eligible for the one-day exam. We've experienced a 12.6% decrease compared to 2018 this year. Also, the number of MJP applications have also reduced compared to 2018. So those are the two trends that I want to highlight for those statistics. And also just general increases. The number of attorneys placed on the motion has went up compared to 2018 by 6%. The number of just attorney applicants, that is not for the bar exam, but attorneys who register with the state bar has gone up about 8%. And also the number of law students that register. That is a requirement as part of BNP code 6060. So we have experienced an 8.2% increase compared to 2018. Again, the other number I want to point out that is the first time that appears on the key indicators is the number of applicants who have registered for the Law Office Study Program. As you can see, they've been incorporated. In May, we received 27 applications, and in June, we received 24. However, the cumulative number that we have to date for 2019 is 85. These are submitted applications, so they could include a few that might become ineligible and so on, but these are the incoming applications for the Law Office Study Program. Are there any questions about the key indicators? All right.
Seeing none, the next item is the schedule for the October 18th meeting. For your information, we don't know yet about the orientation because we don't have any new members that have been appointed. We do anticipate in the next couple of weeks that action will be taken by the California Supreme Court in terms of vacancies, and I'm not sure what the schedule is for the other appointing authorities. Yeah, Paul?
So, for planning purposes, if we were to have no orientation, would we move all the business up? Because I was thinking of just going at that point.
Yeah.
Do something to screw up my schedule if we were to change that at the last minute.
Well, one thing that I think everybody needs to be aware of is if you look at the October schedule, we have an orientation session from 9 to 12. That orientation session is also going to include CORI training and fingerprinting, so it'd be beneficial to have all of our CBE members for that session. So we're going to get trained on the procedures for handling information or results from DOJ that you often receive here through informal conferences or determinations from informal conferences. So I think it's best if all members plan on being there in the morning.
Okay.
Yes, Larry?
You may want to make that clear, because I assumed that I wouldn't have to be there in the morning.
Oh, yeah.
Even though I'm local, it didn't matter, but, you know.
Yes. Well, and that's why I had it on the agenda that I wanted to note that the orientation, we're opening it to all CBE members. So we're going to cover some of the same material, but we're also incorporating a CORI training. All right.
Okay. The next item is the schedule for the 2020 committee meetings, which is in your packet is attachment 0-105. That's for your information only. Yes, Paul?
A couple of observations. It looks like we are meeting one less time next year than this year and probably previous years.
Yes.
Why?
So a couple of things. So we've had a few meetings that have ended early. We had one that ended as early as 11 a.m. And with some of the changes that are coming up, so the implementation of board recommendations, for example, for informal conferences, and also for staff to be making initial determinations and for the CBE to be hearing appeals, we anticipate that we'll have less items on the agenda. The other thing is that we kept certain parts of the schedule the same. For example, we've never met in May because that's typically when the NCBE has their annual meeting, and we've kept that. We also we don't meet during bar exam meetings as a group. So in February and July we don't meet. However, in February we will have an exam committee call, and that is for those appeal TA petitions. So the idea is to create more packed agendas and to gain more efficiency that way. So the schedule was reduced by one meeting compared to this year.
One other question. I guess I was kind of hoping that if we freed up time, we might talk about policy items more, but so far that hasn't really been occurring. Secondly, this is a minor question, but the December 2020 meeting mentioned subcommittees as well as the committee, and I was wondering if that is telegraphing some kind of change back to having the subcommittees meet more, which we eliminated recently, or if that's simply just perhaps an error in the way it was described.
Described on the agenda?
Oh, described in the list of upcoming meetings for next year.
Okay, so we still need to keep the exam subcommittee together for those time-sensitive petitions. They're the only committee that have the authority to act on behalf of the committee.
No, I'm not talking about those meetings in between
Okay.
full committee meetings, but the full committee meeting for December is described as both subcommittees and I don't have it up on my screen right now, but and the regular committee. And I was just wondering if that was signaling a return to the old way where the subcommittees would meet first and then the full committee would meet, which was something we eliminated again in the name of efficiency,
Yes.
which I'm starting to regret, but that's that.
Okay. No, we're not going to go back to that model.
This is our last meeting.
Okay.
Any other questions? Okay. The next item is the presentation on CAPA preliminary findings.
All right, so as we discussed previously, the State Bar has developed and implemented a survey for all California attorneys to assess the knowledge, ability, and skills required for entry-level attorneys. We have a committee member here, Robbie Brody, who has been on that, served on that CAPA team. The study, again, it's intended to provide insight on the connection between the California bar exam and the skill set that I've described. And it's a continuation of a series of bar exam studies aimed to looking at factors impacting the decline in the passage rate. So the project is currently engaged in data collection. However, we've invited 2 staff members from the Office of Research and Institutional Accountability to present on the preliminary data that we have on CAPA. So with that, I want to invite Ron B. and Eli Wallach to come and present to us these preliminary findings. Welcome.
Good morning, everyone. My name is Ron B.
I'm Eli Wallach.
Today, we're going to just give you a brief update about the status of the CAPA study, California Attorney Practice Study. Many of you are aware of the genesis of the study. Shortly after the completion of a series of bar exam studies in 2017, we began to plan for this practice analysis study because one of the bar exam studies' content alignment study indicated that the basis for evaluating the content of the bar exam is somehow outdated, and we need to have a more up-to-date practice analysis study. Furthermore, it needs to be a little more focused on California attorney practice. So planning for the study in 2018, we got everything started in late 2018. But first I want to give you an update that I have previously mentioned about the purpose of the study, which is really to ensure the content of the bar exam reflects the attorney practice, and it provides also a strong documented link between the bar exam content and current legal practices. It also assesses the adequacy of the format. The information will tell us, given what's considered important and the current practice, what's the best way of testing those knowledge and skills. It also, the information will provide information as a blueprint for question development in the future and inform the development of minimum competence definition. So the key project milestones, as I previously mentioned, in late 2017, we started to plan for the outline of the study. And one of the things is we want to have adequate funding for the study because part of the study involves different ways of sending out the survey. That was a key component of the study, different than a lot of the traditional practice analysis study. In August last year, we got awarded from Access Lax Institute to fund the study. And we convened the first kickoff working group meeting in December. Following the December meeting, after discussing the framework of the survey, we convened a volunteer attorney panel to go into the detail of providing classification of knowledge and tasks. That was the basis for populating the survey later on. After the initial draft of the survey was completed, it went into a series of pilot testing in the field. Getting the results from the pilot testing, we further modified the testing in the 2 versions of the survey. And in order to encourage participation in the survey, especially for the traditional survey, we started a PR campaign. That was very helpful, involving social media posting, creation of a few video clips and paid ads, and also a drive to have attorneys sign up to participate in the survey. And we launched the survey early this month, and after getting the data together, doing further analysis of the results, we'll provide some early results to a focus group to validate the results from the survey. That will be after our meeting with the next working group to present the results of the study, and final report is expected at the end of the year. Throughout the working group meetings, I can present here some of the key discussion points. One is at the beginning, it involves the organizing principle of the survey design, whether it's task-oriented or it's content-oriented. Task related to what attorneys do on a day-to-day basis. Content is the knowledge and skills used to perform those tasks. And traditionally, the survey for these practice analysis could be oriented either toward the process, task, or content. There are a variety of ways of organizing these questions. And at the end, we decided that we need to cover both in a very logical way, and that was the structure of the survey design that we adopted. Related to all of the questions on knowledge, skills, and tasks are ratings that we ask attorney participants to give us the information. And job analysis study usually involves 2 elements in the ratings. One is importance, the other is frequency. Usually they use the 2 to create a composite index based on how important the knowledge and skills are and how frequently they perform certain tasks. As a combination of the 2, they can establish a threshold to say entry-level attorneys, this is where they are expected to have the knowledge and the skills. Some additional helpful scales we also discussed involving whether they are expected to perform certain tasks or to acquire the knowledge at different points of time in their career. And we also considered another one just because one of the survey form allow us to ask a few more questions, which has to do with the depth of knowledge, how cognitively complex the knowledge and skills are in their utilization of those skills to do their work. And we selected 3 for each of the survey. The traditional survey, I'll go into a little more detail later on. Traditional survey used the 3, and the experience sampling method used the 3 with 2 overlapping between the 2. Incentive to encourage attorney participation. That involves the creation of this very effective PR campaign. We are seeing the results from the response rate. Target survey response has to do with the question of who should we ask the question about the knowledge, skills, and tasks expected of entry-level attorneys. In NCB's study, the target audience are attorneys with supervising experience. They ask, from your point of view, what do you think are required for entry-level attorneys? We had similar discussions about what the best way of getting to those questions, and we decided that we're going to have the same set of questions for all of the active attorneys, and based on the differences in years of experience, we'll draw inferences based on differences in the response data, and then come to some conclusion about what characterizes the differences in the response according to their experience level. Survey method, traditional and experience sampling. One of the issues in the design of the survey, Traditionally, it involves a long list of tasks and knowledge and skills, and the survey respondents will provide us the ratings, whatever rating scales you select. And typically, you would have a survey including 200, 300, 400 questions on tasks, knowledge, and skills. And typically, it takes 40 minutes to 1 hour, and the response rate usually is not very good. And as an alternative on a testing basis, we want to use something that's easier to respond with. It's called experience sampling survey. That involves initially in our design sending out what we call onboarding survey. The attorney will tell us their practice and some other demographic information. Once that initial onboarding survey is completed, based on those who responded, we send out subsequent daily pings. We call daily pings is the notification during a 1-week period for them to respond to a set of very simple questions. What are you doing? What's the knowledge that you use? And how important you think these things are? So typically based on the response data, it takes less than 2 minutes to complete the survey because of the simplicity of the design and also the richness of the data. We can use this to supplement the traditional survey design to cross-validate the findings between the two. And today I'm going to present some preliminary results from the ESN survey based on 4 days of data last week. It's going on for 3 weeks. We're collecting the data on subsequent pings. Early this month, from a list of 190,000 active attorneys, we divided it into 3 groups. We are collaborating very closely with NCBE, who's doing a similar study simultaneously. So the mailing list was divided randomly into 3 groups, involving our traditional survey, experience sampling, and NCBE, almost distributed at around the same time. And with 1/3 from the ESM survey, the initial onboarding response rate is 18%, gave us the information so that we can create the subsequent ping distribution list. And the subsequent ping response rate based on 4 days and up to today, it's been very consistent. About 65% of those who participated in the initial onboarding continued with the daily pings. And younger attorneys, they get 3 pings a day, and older attorneys with more than 3 years experience, they get 2 pings per day for a total of 10. And traditional survey, it's trickling in every day. As of yesterday, we have more than 2,600 responses, which is about 4% response rate. And based on 4 days of ESM survey results, just lightly scrub the data without going into depth. I can present some preliminary results on the patterns of the responses. This first slide shows the results from the onboarding survey, which we asked the attorneys to tell us what's their practice area. And you can see distributions of the different practice area across a different experience level. And this is, sorry. And this is, practice area. This is a somewhat simplistic view of the distribution of the practice area because attorneys, they have the option of selecting more than one. So going into detail about those who select more than one, in a different kind of a visualization, you can see the connection between clusters of different practice area. For example, you can see those who selecting more than one, they tend to have a large percentage select business, civil litigation, and other kind of a related practice areas. So the overall picture is more complex than presented here. And those details we'll get into a little bit more. And similar kind of a interconnected structure we'll be able to see in their responses to knowledge that they use and the task. The goal is to see clustering of those things in the different sections of the survey so that we can distinguish the differences among attorneys with different experience levels. Areas of responsibility, that's the first question we ask them after they get the ping. It refers to a specific time of the day. They tell us what they were doing at the time. And it's based on a list of more than 110 specific tasks. We group them into about 12 categories, and those 12 further fall into these four major categories related to maintaining relationship, research and analysis, practice management, and resolutions of the case or matter. And from the beginning, with the live real-time report of the survey, we can see a very large percentage of their time were spent on doing research and analysis, and some difference across different experience levels. The next one is related to the following question. After telling us what they were doing, the question is, what's the knowledge that you are using to perform those tasks? The knowledge, we created 21 what we call knowledge domains, and within each of those knowledge domains there are sub-legal topics for a total of more than 130 subtopics altogether. And this is also a high-level view of the distribution of different knowledge domains. Also, from very beginning, we saw a few of them dominating the trend from almost the first day of the results, which is civil procedure is the highest ranked, and contract, torts, criminal law, with some differences across different levels of experience.
Is the purple bar is the other?
Yes.
And how many different knowledge domains is contained in other?
That other is
Or other
an
is just its
open-ended
own.
text
Okay.
field. And I glanced through some of them, and most of them look like they could be easily recoded into the existing category. So we need to spend a lot of time. Altogether, we expect about 10,000 selecting the other and give us the specific knowledge domain that we'll spend time to recategorize them into, to the extent reasonable, to the existing categories.
Okay. And then on that first slide where you showed the distribution of practice areas, was I right in thinking business was relatively high up there in terms?
Yes. Mm-hmm.
But I don't see it here. Is business contained within these other knowledge domains? Was it not its own knowledge domain?
It's not its own.
Okay.
Yeah. And the connection between the two is another level of analysis. What practice area tend to use what cluster of knowledge domains? That's another way of looking at the convergence of all of the data to present different patterns.
So one of the things for the committee that we've talked about internally, again, this is very preliminary data, but when you look at the distribution of knowledge across these domains, you see about half of that distribution is, setting aside the other, it's about 4 to 5 knowledge domain areas. And that's as distinct from, of course, the 13 topics that we are testing for in the bar exam. So just to make that very clear connection between what the information we're gathering here and the kinds of, to speak to your comment, Paul, maybe policy issues that the committee is going to have to grapple with. I think these results are really going to give you a lot of material to start talking about what it is we're learning, about what new attorneys need to know, and then what we're testing for in the bar exam. So this is really interesting to see that the dominance of only a few knowledge areas.
And this result from the ESM survey, we didn't ask them how often they do these things or use the knowledge. It's simply they're telling us, and it's a frequency distribution. As opposed to traditional survey, they were given the list of all of them, and the respondent will tell them on a regular basis from 1 to 5 how frequently they use these results. So the comparison between the two, this is actual frequency distribution, the other is 5-point scale rating. We'll have to find a way to cross-validate the two results. And also, as I mentioned earlier, the different scales, this is just one dimension of the results, which is frequency. Importance or criticality is another one, something that you don't use frequently, but it might be very important. So the combination of the two will inform the decision about what should be covered on the bar exam. And going into some of the preliminary results without a lot of details or breakdowns of the rating scales, this is one of the rating scales used in both surveys, which asks at what point in your career you're expected to perform the task that you told us you were doing. And you can see the arranged in that descending order. The top one, they were expected to perform later in their career, and the ones at the bottom is something that they were expected to perform almost at the beginning of their career. One is stands for 1 to 4. One is first year, 2 is second year, third year, and after third year. This is just the average of those 4. At a glance, it seemed to make sense. The higher ranked ones tend to be a little more complex, requires a little more experience, and the lower ones, we can use that information as part of the discussion about what should be expected of entry-level attorneys. The next one is criticality. The higher the score, the more important it's considered. So litigation is ranked at the top. Drafting, writing, negotiation, and closing, those are all at the top. And at the bottom is communicating with others, maintaining client relationship, supervision, and collaboration. Without knowing what legal practice is like, it seems to make sense to me too. The last one, this is a scale that we use only in the ESM, from 1 to 5, using what's called the Bloom's taxonomy of cognitive complexity or depth of knowledge. 1 stands for something simple you can just recall, and 5 involves the highest complexity of cognitive activity, which usually involves synthesizing and having deep knowledge of certain topic. And ranked here, you can see constitutes knowledge. Whenever they told us that's what they were using to do their work, it's considered involving the highest cognitive complexity. And at the bottom, we also have a category of non-legal kind of a knowledge.
Can you describe what's in there?
Non-legal. Non-legal, we provided 4 additional subcategories: accounting, statistics, and some basic computer knowledge, probably even included artificial intelligence. I don't remember. And then there are a lot of others also check the other box under non-legal, and we have a lot of other detailed information that they told us, the non-legal knowledge they were using. Yes, artificial intelligence is also there. Research design. So even though this is very preliminary results based on 4 days out of all together 15 days of a ESM survey, we got very high response rate. And this particular method we're using initially on a kind of a pilot testing basis. There are a lot of uncertainties. And as of now, we're very happy about the results. It will give us very valuable information The consultants from the initial proposal, they weren't so sure about this idea, and we're very happy that the Scantron, the consultant we're working with, they embraced this method, and we'll have very helpful information. A lot of other people to thank also for supporting this method. The working group, certainly, the attorney panel. Eli was very good in using this tool. Initially, we weren't even sure whether we should hire a contractor to create a customized tool of this. We were able to use the tool, and Eli was very good to design and implement the survey on this Quatrix tool, and certainly the support from Leah. She said, just go for it, and we did it. Any questions?
Ultimately, you're going to have all of the ESM data, all the traditional survey data, and you'll be able to show the results for first year, attorneys 0 to 1 year in practice, 2 to 5 years. However, you're going to be able to display the data in a way that shows us, for example, depth of knowledge. Does that differ for attorneys within year 1 versus year 10 of practice?
Yes, the years of practice, we asked, I think, in the categories first 6 months, second 6 months, up to third year, and then 4 to 5, 5 to 10, and over 10. So all of these distinctions, we can look at the different patterns in the data. What I showed is just aggregating the first 3 years. And initially, just a little more analysis, I saw distinct difference in the practice area that they select. Because it's more than one choice selection, younger attorneys, especially the first year, they tend to select just one. And the more experience, the more you tend to select more than one. And in a different view, I have it here, maybe you're interested in taking a look at a different kind of visualization of the data on if it works. Just a second, I'll show you a different view of. This is practice areas where people selected more than one. You can see the connections. Each of these represents a specific practice area. And the lines, sorry. Okay, it's not viewable there.
It's not viewable on
Yeah.
the screens.
We have a different view looking at the network structure of the different practice areas to see the connections among them. And we see very clear different kinds of clustering for first year and second, third year attorneys. So those information will be additional valuable insight to look at the different patterns of a career, knowledge, and practice. And then there are a lot of information from the traditional survey we haven't started to look at yet.
Yeah, there's a lot of information to present, and even there's so much work that went into it with the working group and panel. And right now we're showing sort of a higher level of tasks and knowledges. But as Ron said before, within each of those levels, so when you look at litigation, there's 19 subdomains under litigation that we could also look at. So each one of these fields, there's going to be data within those fields as well. So it's really a rich amount of data that we're gathering about legal practice with this.
No, the depth of knowledge, isn't that the Bloom's taxonomy, 1 to 5?
Yes.
Maybe you can describe that again.
From 1, it involves the simplest kind of cognitive activity. They call it as recall, the ability to recall something simple. The second level is to understand some basic facts in a subject matter. And the third level is to be able to analyze, apply the actual knowledge in an actual setting. The fourth, the higher level, is the ability to use the information and go into a complex analysis of the topic matter. And the highest level is the ability to synthesize the knowledge across the different topics.
Thank you, Chair. Thank you for your presentation. I don't think I'm on the mic, though. Good morning. Thank you for that. I just wanted to ask in regards to the State Bar is doing a lot of work in diversity and equity. So I'm looking for what aspects of this report that we'll see at the end of the year that it will address some of those things for existing legal practice, as well as looking at age demographics. Some of the things I keep hearing in my networks is that the industry is changing and constantly evolving. So I'm looking at what are millennials going to see, and then what are boomers and Gen Xers, and then interestingly enough, even Gen Z have the ability to become attorneys at this point, which is surprising. But my thing is, how are we ensuring that this report is more long-term and mitigating any of those impacts where we're measuring certain aspects that maybe only apply to a certain realm, whereas maybe there's a new way innovative way of doing things that might be more efficient or more likely to provide equitable results. So that's pretty much, I think, what I had.
The question about the differences reflected in the data across different experience level, to what extent it's an indication of differences in experience level, or as entry-level attorneys, they enter into a legal profession that's changed compared to those who have been in the profession for over 10 years. This is something we don't have the answer because this is a time and point, kind of a snapshot of the industry. To be able to see how the legal profession has changed, you probably can infer from the differences between different years of experience. But without being able to have this kind of a ongoing survey, similar survey, you don't have different time and points to compare the changes. And this kind of a study, typically it's recommended that we do it between 5 to 7 years to gauge the change in the industry.
Thank you again for presenting the results of the survey and for doing such a great job with the work. I'm one of those new attorneys who did receive the survey, but I have some complaints about just the advertising of the survey. Specifically, just some miscommunications about that it's separated into 3 different surveys from the get-go. I have my complaints with the State Bar of California's Twitter account, not providing enough information on what the different types of the surveys and just promoting one survey over the other. Haven't received any follow-up information about the surveys in general, as in it was only, I got the new one, which is the 20-minute long survey with a follow-up 1-hour article for MCLE credit, which is kind of deceptive, and that if you complete a survey, you get the MCLE credit. It's a follow-up to get the MCLE credit. It's just different stuff like that it seems confusing or not even keeping on people's radars. So when you mentioned the 4% response, I can easily see that because I had to dig through my emails just to find the one that was sent on August 1st or something. And I think that it gets buried, and also the mere fact that you have 3 different surveys and only promoting one survey on the State Bar of California's Twitter account without stating anything else, it's just confusing in terms of promoting this type of research and study. Also, on the previous screen, I believe, I noticed that you removed the IP and intellectual property and family law when I think 2, 3, or 4 previous screens ago you had IP and family law separated as an analysis. I was just curious, why did you, for the previous screen, why did you remove IP and family law and lump that into the other, I guess?
Practice area, there's a total of 35 selections, and showing that distribution, it's a very long list. So when I looked at the distribution, a lot of them took up only 1%, 2%. So just for having an effective visualization, I just lumped all of those with less than 3% and grouped them into the other. Obviously, we have the underlying data in a different setting, and the report tool will just show all of the details. And this is just for purpose of a preliminary view of the high-level view of the results.
Anything about the communication about the survey? I did not understand that we were only promoting one survey. I thought folks were randomly assigned to 3. The 3 being our traditional, the ESM, and then the National Conference of Bar Examiners, which is also doing a job analysis at this time.
From the beginning of the campaign, in the sign-up page, where we send out email for, I think, involving email and letter also going out. The first time they see the different survey is on that sign-up page. We provided explanation about the random assignment to one of the 3. And afterward, we created a FAQ. In the FAQ document, we also made it clear that your participation is randomly assigned to one of the 3. So there might be some areas that could be confusing. We also have people, after getting the initial onboarding, they complain about why are we still getting more every day. So it depends on the level of detail that you were able to see. Yes?
And just a quick follow-up. One of my main complaints is the Twitter account for the State Bar of California. I recall a week ago, so they actively were promoting, don't forget to fill out, I think the traditional survey, whatever they call it. That caused, when I read it and other people read it, caused a lot of confusion because it's like, wait, there's a deadline for all surveys now, which was only for one survey, but they did not make it clear it was only for that particular survey, for that particular process, which is the traditional has steps. Like, I think you have to do 1 per week, which is just...
That's the non-traditional.
One or the other. But when I read that on the Twitter account, without them addressing that, the other 2 surveys or whatnot, in my mind and in other people's minds, we've been told that there's only one survey. So when it's separated into 3 different surveys and then having the Twitter account of the State Bar of California saying, don't forget to complete your survey for this one because the deadline's coming up last week, that was confusing. And that's why there might be better promotion or activity if you send out a reminder email and make it specifically clear you've been selected of 1 out of 3 surveys. Because I saw the email, I just clicked or whatever, but I didn't understand because I think it got buried in the email context or all that you will be selected by 1 out of 3 surveys. Here are the 3 surveys. Each one has a different requirement. It wasn't made clear at all when I first signed up. So, and just the miscommunications like on the Twitter account stating that one of the emails, one of the service deadlines is coming up, which was last week again. It was just confusing. And in people's minds, like, oh, I can't do the survey anymore.
Okay, thank you for telling us that. I think that our campaign is still ongoing. I'll try to fix that. And even though from the beginning, we distinguish the 3 surveys. As you said, it's worthwhile probably just continue to emphasize you need to only complete 1 survey. And the reason we have more promotion for the traditional survey, as you heard me saying, we have a little more challenge in getting higher response rate for the traditional survey. But I'm confident that we will have pretty high response rate because based on early results, we have 6,000 attorneys who opened but didn't complete the survey. So we're hoping that by the end of this month, we'll have more follow-up to complete the survey. Yes?
Is it possible to put back on the board the criticality slide? I am confused what is on the x-axis. I couldn't see it from my seat.
Which one is it again?
The criticality?
Oh, criticality. It's a 1 to 5 scale. 5 is the highest criticality. And then the language we used to measure criticality is to degree of harm. If you don't have proficient knowledge or ability to perform, what's the degree of harm that you think will result from the task? And 5 is greatest harm, and that's a measure of the greater importance associated with the task.
This is my last follow-up, sorry. No, thank you again for answering all my concerns. That really means a lot, and for other people as well. I was just looking over my past emails. Again, I'm a new attorney, so I got the email. That email with the 3 different surveys was sent on June 24th, which is a long time ago. And then the only email I received after I did this, you had to sign in or sign on to do the 3 other surveys that you randomly all selected. And I just received an August 1st email at 6 o'clock in the morning, which is fine, about not stating whether or not the survey I was selected is doing it. It's just and I was selected for the National Conference of Bar Examiners email, but not stating or linking at all that it was in relationship to the 3 surveys I was randomly selected. So it's like, is this another different survey that people are doing? And then I recall also at my job employer sending out the email saying, you need to do one of these, you need to do this survey because they're collecting information. Of course, you can't do that if you're not signed up, and that's only 1 out of the 3 surveys that you randomly selected. So it created more confusion of, wait, am I supposed to do this one, or who's collecting what? When back in June 24th email, which again is so long ago, stating that you have to sign in to partake in 1 out of the 3 randomly selected surveys. So again, there's confusion in terms of my employer, my friends, what I'm supposed to do on this, and that on the August 1st, which is when they sent out the surveys, at least in this email for the National Conference of Bar Examiners one, it did not link it back to the randomly 3 selected surveys. It just jumped right into do this survey. And that didn't connect, and then when I saw on Twitter, by the State Bar of California, that, one of the other surveys were ending, it confused a lot of people in terms of, wait, am I supposed to have this completed when it's one of those, it wasn't made clear that there's 3 surveys out there, each with different requirements, that they're linking back to what you signed up previously. That's just my main concern right now. But again, thank you for talking about all this and just for showing more about how the entire process of it.
Thank you. This is very helpful. Maybe it's just information overloading from our over-aggressive campaign.
Are there any other questions or comments? If not, thank you very much.
So when
Oh, I'm
was the
sorry.
deadline?
Which one? Which survey?
That's where I'm getting confused. The Kappa.
It's all, two CAPAs. One is traditional, the
Yeah.
1 hour long survey. The other is the daily ping.
There you go. All right. And then when the deadlines?
The daily ping, you get assigned to, or you actually choose to participate in 1 week.
Okay.
And every day you get the ping. And over that 1 week period, you have until that Sunday to go back if you haven't completed any of them.
When did the ping stop? Like whenever you
Friday.
Friday.
Yep. Any week that you chose, you will get it only during that 1 week.
So this is a continuing daily ping for the
Daily
next 4 or
ping.
5 years? Or is it
No,
going to
no, no.
end this year?
No,
3
just-
weeks.
Okay.
For the participants, it ends at the week, at the end of the week.
Yeah.
It's just a 1 week participation. You
Well,
get 10. Yeah.
I'm sorry, man. So we're stopping collecting data on what date?
And then the traditional one.
Traditional is the end of the month.
Okay.
It's the same survey. It's just sitting there. You can go back and fill it out anytime.
Okay.
And for the ESM, the 3 weeks they could select was last week, August 12th through 16th. This week, August 19th through 23rd today. And next week, August 26th through August 30th.
Uh-huh.
On the onboarding, the ESM participants select which week they would like to participate in.
Okay. So
So,
it's this month.
yeah.
Okay. Thank you. I appreciate that. I'm sorry.
No, good question.
Okay, thank you very much for
Thank
your
you.
presentation. We're going to finish up
A lot of moving pieces.
the update on the pending office admissions and state bar activities.
Okay, great.
Bobby?
So we're starting with an update on CAPA. So for this portion, we're giving each of the CBE members who have been selected to participate in each of these subcommittees or in these working groups the opportunity to provide an update. So Robbie, I'm not sure we heard about the preliminary data collected for CAPA, but is there anything else that you would like to add from a CBE member perspective that you want to talk to the group about?
Happy to say things like preliminarily issue spotting analysis are at the top of the list, which are the very things we currently test for in the California Georgia. So very interesting. More to come.
Great, thank you.
Thank you. The next item is an update on moral character. Jim?
Sarah, you want to start this?
So good morning. We don't have much of an update from last time. So we've only had our first meeting in June, and our next meeting is next week in the Los Angeles office on Wednesday. So the work's continuing.
And you're welcome to come by and ask me questions and give me input. Done.
All right, thank you.
Okay, thanks. And update on the committee on the state bar accredited and registered schools. Okay.
Jim, could I make a comment first?
Yes.
I actually happened upon the agenda for their meeting next week, and I just noticed that there are no attachments that the public or even us, if we wanted to see what's going on, what this committee could look at. So I would encourage staff to get the written materials, even if you, as is so often unfortunately the case, just bring them to the meeting afterwards. If you can attach them to the agenda, then we have a chance to see some of that. You know, it's transparency is a word we use, right?
Mm-hmm. Okay.
Green?
Okay. Thank you, Mr. Chair. Good morning, everybody. I am your representative on CS Bars. So I'm just going to go through some quick points, give you a few recap. And if you have any questions, feel free to ask as needed. So as you know, May's Law School Assembly, there was a Law School Assembly in May, which has been a topic at CBE. The launch of the e-newsletter to deans will be published again in the month of August, and then the release of the NPR forms with a 5-year cumulative pass rate is going to be a topic on today's agenda for the committee. Also, in regards to the collection of demographic data, which is one of our educational standard goals, the State Bar is expanding the data collected about unaccredited and accredited law school students and faculty to match the data collected by licensees through the Bar's most recent survey. Schools were empowered to be participant of an informal working group to help with the rollout, and those volunteers include Concord School of Law, Santa Barbara and Ventura College of Law, JFK University College of Law, and Northwestern California School of Law. Next is the review. I'm kind of loud, huh? I can hear it like buzzing. No, I'm good? All right. Review of guiding principles for the creation of a deemed accredited status and best practices review, which is one of our educational standard goals, number 3. So this topic is not noticed for discussion today, but it will be on the next agenda. The deemed accredited status would allow law schools accredited by a regional accreditor to earn a modified deemed accredited status that will allow regional accreditor status to be substituted for reporting to the State Bar, as well as other elements such as the NPR will still be reported to the State Bar. And then lastly, the research regarding the deemed status in Appendix I has uncovered a number of best practices and updates that would clarify the current accredited and unaccredited rules, that these will be proposed for incorporation into the rules. Staff will be reviewing the major change rules based on the committee's guidance, provided after several major changes over the past year. And that concludes my remarks. I'm open for any questions.
Are there any questions for Kareem? If not, thank you very much.
Thank you.
And actually, at this point, I'm going to announce that Esther, as the vice chair, and I, as chair, have made a couple of appointments. An interim appointment to a vacancy on the Committee of State Bar Accredited and Registered Schools for 3 years of Jay Freiberg, Dean and Professor at the University of West Los Angeles. And then also an interim appointment to a vacancy on the Law School Council for 1 year of Anthony Nidwicki, Dean and Professor at Golden Gate University. So, for your information.
Really quickly, I had the pleasure of working with Jay Frickberg on a site inspection, one of the best, and I can tell you that CS Bars is going to be very well appreciate his knowledge and his experience. So, great job there. Thank you.
Thank you. And do you want to?
Yes. So we have a couple of recent developments that I want to update everyone about. The first is related to the AIM system. This is the Admission Information Management System. As you recall, we launched on March 1st, and that launch included the posting of 3 exam registrations. That included the July 2019 bar exam, the 2019 June first-year law students exam, as well as the legal specialization exams. As we've received applications, we learned about system glitches. Initially when we launched, and I brought these to the committee, I talked about the complexity and some of the challenges that we had with integrating our payment process system. So it led to duplicate payments that we addressed very early on. I think in the first week, we experienced this problem, and it was resolved by the end of the week. But as the exam application process was proceeding, as we gathered more applicants and as we prepared to go into these exams, we learned about other issues. And also, I just want to remind everybody that when we implemented the system, our vendor was on board with us for the first 3 weeks. Some of these issues that have surfaced happened after that point. So I mentioned some of the, as we progress through the exam administration process, some of the problems surfaced. One that some deans experience are the fact that we send out a preliminary certification list. This certification list goes out to the deans to inform us of that all education requirements have been met. So for graduating students, they certify that the student will indeed get a JD. So we ensure, and has not been received, but what we're trying to do is ensure that people who are eligible to sit for the bar exam can, and that the timing of receiving your JD diploma does not impact your eligibility. So that's why we prepare this certification list. What we experienced was that some of these certification lists were inaccurate. And as we dug into some of these problems, we're learning that data migration has been an issue that we need to resolve within our information management system. There are other data migration issues that have created workarounds for us in the office. We are now, for example, verifying every single eligibility criteria to get somebody on the motion to ensure that our data is accurate. Because like I've mentioned, our data migration did create some problems. So in essence, what we've done here internally is the AIM steering committee reconvened. We had not convened after the launch. Again, that group includes members from executive leadership, from the Board of Trustees, IT staff, and operations staff. And what we're planning to do is to conduct a root cause analysis as to how to address other issues that might be coming up, whether it's system functionality, which we don't anticipate at the moment, and how to address some of the data migration issues. Because we've launched in March, and it's been a long period, importing data from the old system could present challenges as well, because some of that data is now outdated with a lot of action happening in the past few months on some of these cases. All this to say that we have been meeting with our vendor to explore, to describe the problems and explore what some of these root cause analysis might be. So what could be impacting some of this. So we met with Slalom this week for 2 days. The idea is for the group to prioritize some of these issues and bring it back to the steering committee to come up with a long-term solution to some of these issues. So I just want to alert everybody about the problem, to describe the steps that we're taking. I hope that we have this evaluation as to what paths we're going to take to remedy some of this before the next meeting. So this will be on the agenda for our next meeting as well. With that, does anybody have any questions about the AIM system?
Yeah, Amy, this is the vendor is the Salesforce, right?
It's a Salesforce system, and our vendor is Slalom.
Okay, and this is the group that we decided to choose over a different competitor,
Yes.
right? This is the company that we decided to pay, I think, $2 million?
Yes.
Versus the startup that would have been like a quarter of that cost.
I can't recall the numbers, but there was a difference between the two.
And how much would it cost going forward to fix the system and errors?
That's what we're trying to evaluate. I think part of the determination is where those problems lie and what steps we'll take to remedy those. So there's more to come on that.
And would the state bar be bearing the costs, or would Salesforce or the vendor bearing the costs of fixing it?
Most likely we'll be paying for that cost.
And how much are we looking at?
We don't know yet. Again, I think it's a matter of determining, prioritizing the issues, determining how much we can take in-house, because we do have a Salesforce vendor, a Salesforce experienced programmer on staff now here at the State Bar. But I think we're trying to assess how much we can do in-house, how much is going to require support from a vendor, and then and also prioritizing what needs more immediate action.
What was the reason why the vendor decided not to take on the cost of repairing something that they, I would arguably would say that they cost?
I'm sorry, say that one more time, Alan.
Did they give us a response as to why they are not bearing the cost of repairing this issue?
Well, I think that, we've we've gone through some of these issues in terms of what is like a functionality that wasn't built into the system. We're trying to also determine the origins of each of these things. Could this be caused by data migration? Data migration is has two roles. I mean, we need to build a system that can accept the data, and there's also the process of preparing the data to come in. I think we're trying to determine, what aspects impacted successful data migration, and until we know that, it's hard to determine, who caused, what the root cause was for some of this unsuccessful data migration and
Was
integration.
data migration not within the scope of work?
Well, we finished and signed off on the scope of work, and some of these problems we learned about after. What we're trying to determine is, was this a result of bad data versus functionality? And that's, I think, why I'm struggling with answering your question as to who should bear the responsibility of this.
So
let me just jump in, because I think we've had some similar issues with a larger system that we deployed at relatively a similar period for our discipline system. I think what Amy's trying to say is data migration is a joint responsibility between the client and the vendor. There's the aspect of making sure the data is clean and ready to go over. Yeah. There's the aspect of the system being able to accept the data. And there's the aspect of testing and review and auditing of the data migration to make sure it was done accurately. And that's really a joint effort. So it's really difficult, certainly for us at this stage, to point fingers at either the vendor or ourselves with respect to these issues. And so this root cause analysis that Amy's referencing will allow us to begin to better understand sort of the source of some of the problems. But I think it would be premature and a bit simplistic at this point to assume that the vendor is the only entity that created issues and therefore should bear 100% of the cost of the fix. And I also want to say these issues are, I think, concerning, but they are relatively normal for the implementation of a large new case management system. And anyone familiar with what's going on our discipline side would be able to say yes. We have to keep things in perspective. So we've got a lot of resources on this now, and it will get fixed, I think is the bottom line.
Kareem? Thank you. So are we seeing any reduction or impact in services that we're providing? I know we're moving pretty fast because that AIM system was supposed to help us move a little more effectively. Are we seeing anything delayed, or do we have any timelines that are being stretched out in regards to reporting or any kind of new processes that we were implementing?
Yes. So I mentioned this earlier, that there are some workarounds that require more staff time. So, it's pulling in resources. So, for example, we are looking at everybody who's placed on the motion on a weekly basis and re-examining their records for accuracy to ensure that we don't erroneously put somebody on the motion list who should not be. That is, that we're not granting a license to someone who has not met all of the requirements. And so that is taking some time in terms of productivity. Staff that could be advancing in other arenas are not able to because they take this on a weekly basis. And roughly, we're looking at about reviewing between 20 and 40 cases a week. We have had peak periods. For example, at the end of the February bar exam, when results were released, we did have 1 week 997 cases to check because the total number of people would pass the bar exam and satisfactorily met all of the requirements for getting on the motion. So again, to answer your question, yes, we've seen an impact. I can't measure how much because it's varied from 1 week to the next, which is why this is a priority for us in the Office of Admissions.
So in regards to, I know we get extension requests of certain attorneys, so would it impact that as well? That's something that we decide on as a body.
So, for example, you're talking about like moral character application extensions. No, we're taking on applications. Our system is helping us get cases in. So it's not impacting our ability to accept applications.
So what I'm talking about is that we have issues. So sometimes we get applications where people haven't had the opportunity to get the moral character and then get sworn in. So then they ask for an extension to go through the moral character process. So later on today, we have some discussion about some of those applications. So my only question is, if this process is impacting and delaying, then is that a part of the staff report so that we have an understanding of if we do provide 3 months, well, it's because there's a hiccup in the process. I just want to make sure that.
Well, those petitions are very different. So,
Okay.
for example, we're going to hear some people put in a request because they have not met, for example, the 5-year term limit to satisfy all of the requirements, and they want an exception. That is not related to what's going on with the case management system. We're not backed up enough for 5 years to impact a decision on some of these cases. Those are cases where perhaps something has impeded on somebody's ability, life circumstances, for them to be able to meet all of those obligations.
There's one case in particular where they just need like 3 more months to go to the moral character process. So we could discuss it then.
Okay.
But I'm just, that's where my train of thought is going. So,
oh, yeah.
Thank you.
We can talk about that
Thank
then.
you very much. Yeah.
But there isn't anything impeding to that extent.
Thank you so much.
Okay, any other?
Yes, one last update, and that is related to Senate Bill 544. I think Tara's going to discuss this.
So good morning again. So Senate Bill 544 was approved by the governor on July 30th of this year, and it will become effective on January of next year. So essentially, with the moral character determination process now, we are not allowed to seek, request, review, or consider medical records relating to mental health unless the applicant provides them to prove that they are of good moral character or as a mitigating factor for misconduct. And so admissions management, the executive leadership, and Office of General Counsel will be meeting in September to go over our process and ensure that we're in compliance.
Okay, any questions? Yes, Paul.
Was that bill specific to us or all the agencies that regulate professions?
It's specific to us.
Yes.
Thanks.
Okay, any other questions? If not, I've been informed by Kim that there is a member of the public who arrived a little late after the call for public comment who would like to address the committee. So would you please come forward now?
Good morning. My name is Barda Enning. I'd like to thank the chair and the assistant chair for allowing me to provide public comment. I did prepare a statement, so I'm just going to read it. My name is Marna Enning. It has taken a lot for me to come forward, so I pray that the committee will consider my words and my request in earnest without retaliation. I thought it would be appropriate to present my request in this forum, considering some of the agenda items you are considering today and the committee's new administration and new movement towards transparency. I have taken the California bar 6 times to date, 5 times under the previous administration and once under the new administration. I graduated from law school in 2011 during the economic recession. I have also had my moral character application denied by the Committee of Bar Examiners on account of the fact that after law school, I was a recipient of public assistance, had unpaid parking tickets, and was engaged in a custody dispute for my daughter in the course of my divorce. I was deemed unfit because life happened to me fresh out of law school during the economic recession, and I had no job or cozy bar loan to rely on. The official decision claimed I withheld information pertaining to my daughter's medical records in the course of my custody dispute. During the course of my moral character application, Deborah Murphy Lawson, who I have been informed is now retired, engaged in a campaign to prevent my admission to practice in California because she was made aware of an administrative complaint I filed against her with the former director of admissions, Gail Murphy. The complaint was because she, Deborah, told me that she could hold my application indefinitely when I complained that my application was being delayed by one of the bar exam analysts who lived in my neighborhood. Also, Gail Murphy denied my first accommodation request on grounds that I had missed the deadline to file it, even though I had called her a day after I was out of the ER after being hit by a car and rendered unconscious. In line with her campaign, Ms. Murphy Lawson tracked and reviewed that accommodation request and every single accommodation request that I made afterwards, making sure that she was notified each time I applied to take the bar or requested accommodations. I have not filed a new moral character application since, even after I changed my bar exam ID number. However, I understand those administrations are gone now and the bar is heading in a new direction towards transparency and considering the impact that the exam is having on diversity. Each year, 7 out of 10 people who take the bar exam do not pass. The main reason why I'm here today is that although these administrators have gone, recently my bar examination results were mysteriously misplaced by the bar exam grading department. And when I challenged the outcome based on clerical error, I was told they got lost in the mail. Also, although I registered for the bar on time on April 1st, and the fee for my check was cashed on April 11th, my registration was not actually even processed until after I had called and emailed a request to the bar exam office in June. Additionally, while I was preparing for the examination, I was contacted without consent by my former law school, USF School of Law, to participate in an experimental program claiming to provide assistance to participants by tracking our preparation methods for the bar. I declined participation. I was subsequently contacted again by the State Bar to voluntarily opt in to disclose my results to USF School of Law if I am unsuccessful for the examination. I opted out. Since I went to 2 law schools, I specifically excluded USF from my application because I did not want anyone at that school to be notified that I was taking the examination. Yet, my information was still sent to USF, and after the results were released, I received another offer to participate in another experimental program for at USF for unsuccessful applicants, even though I had chosen to study on my own. When I wrote a letter and an email to the bar exam grading department protesting the release of my records, they quoted Business and Professions Code 6060.25, claiming that my results were provided to the school on that basis. However, the Business Code requires that I consent. It is my understanding that the Business Code requires that I consent to the release of my records. However, I did not consent to the release of my results to USF as required by that law. Although I had some good professors at the school, my entire experience at USF School of Law was marred with racial discrimination, bullying, harassment, intimidation, nepotism. I was blacklisted, targeted, poisoned, humiliated, rejected, and otherwise made to know that I was not wanted at the school by administrators and fellow students. I am still recovering from the trauma of that experience, and these memories have returned for every past administration of the California bar exam. I pray that my faith will one day lead me to forgive the people at the school who were responsible for what I went through to obtain my JD. So as you can see, I want nothing to do with USF School of Law, and I would appreciate if the State Bar would respect my decision and my present appeal and request not to disclose any of my bar registration results or any of my applicant information to that school on any occasion for any purpose whatsoever, as is possible, if possible. I also do not want to be included in any experimental studies in the future without my consent, disclosed or undisclosed. Despite this past, my faith has brought me a long way, and I intend to continue to apply for and be admitted to the California Bar in the future. So I ask you to please respect my decision for anonymity and confidentiality and the proper handling of my admissions records and applicant information so I can prepare and pass in peace. Thank you.
Thank you very much for your comments. We cannot take any action today because the item is not on the agenda. However, I would ask the admissions staff to investigate your comments. Thank you very much.
Okay, thank you.
Next item is examinations. Lisa and David.
Thank you very much. Discussion of 2018-2019 exam goals and accomplishments. That's under Roman numeral 3. Has anybody had an opportunity? Everybody had an opportunity to review them Are there any additions or corrections or any other comments that anybody would like to make with respect to the goals and accomplishments over the past year? If not, that's all I have, Mr. Chair, except that I think one of the more important things is that we continue with respect to number 11, continue monitoring the modified California bar exam and to determine whether or not there are any problems or disparities in the future. Other than that, thank you very much for serving on this committee. Mr. Chair.
Thank you very much. Next item is operations and management. Ravi?
Okay. Has everybody had an opportunity to take a peek at our goals for upcoming months? Okay. I think they're pretty self-explanatory and a good roadmap for us. Tammy, anything else?
No, I do not have anything further to add.
Okay, thank you very much.
Okay. Next item, because Alex has not yet arrived, his plane is supposed to be, he's supposed to be here shortly, but we're going to move on to the moral character. Item A, or 0-500. Mark Torres Gill and Tara.
Yeah, good morning, everyone. This particular item is returning to the committee after initial discussion at the June 2019 meeting. At that meeting, staff presented the proposed guidelines for conducting administrative review of adverse moral character determinations, and the committee requested that a few adjustments be made to those guidelines as reflected on the attachments to the agenda item. The only change that was requested change that was not included was to include a standard of review for the reasons that have been expressed in the agenda. Essentially, that standard of review is not really necessary in this context. So we're asking that these proposed guidelines be received and filed as amended. If there are any questions, I'm happy to answer them.
Yes, Paul.
Yeah, and the precise language is receive and file as opposed to approve. And I'm wondering why this is policy and practice, and we've been told that that's what we're supposed to focus on here more than the nuts and bolts of reviewing the details of things like the moral character applications, and yet we're not even being asked to formally approve this. I'm just wondering why that's the case. Let me ask two more questions, and then you can answer all three. There's a definition of, or there's a requirement to assign a lead interviewer when a committee of two members is undertaking an appeal. What is the point of that? I realize I should have asked this the last time. And then finally, what is the timeline going to be for switching over to staff conducting the interviews as opposed to the committee members in the first instance?
With respect to the lead interviewer, the purpose for that is to designate somebody who actually starts off the questioning and actually takes the primary role in the interview of the applicant. It does not mean at all that the person who's not designated lead can ask questions. In fact, that person can. It's just that the lead interviewer is in fact primary. And
okay, the moderator, if you will.
Right. So, and then with respect to the received and filed, it was more, I guess, more a determination that this is more sort of an administrative process for just accepting the changes that were already requested, by the committee, as opposed to requiring a formal approval since it had already been to the committee at one other time. So that
did we approve it the last time or just receive it?
No, it was the last time. It was in fact I just kicked back a little, in order to make the adjustments. I don't recall that it was actually approved at that time, but it was just felt that the received and filed is sort of a better way of processing this particular item. Not to say that the committee can't continue to, review and comment on the item itself.
Well, maybe it's just optics, but in this environment where the committee is having many roles stripped from it, it matters, or it pulls at a scab, if you will, for some of us.
I understand. And the third, I'm sorry, Paul, I didn't catch the last.
The timeline for the switchover?
Oh, the timeline for implementation?
Yes.
That's going to depend on when the Supreme Court actually approves the amended rules. And I'm not quite sure. I don't know, Donna, whether you know where that is at this point or not. But the Supreme Court, I believe, was supposed to meet in committee, I think, recently.
I think the court is meeting next Wednesday. Whether they'll have the ability to take this up at that time and make a decision, I certainly can't speak for the court. But I know that they have been looking closely at these rules, and I would anticipate a determination, hopefully that's an approval determination by the court in short order. And Paul, I would say that there's a recommended motion in this, but certainly an alternate to that recommended motion would be entirely appropriate as well.
Well, yeah, I'm personally, the ship has sailed about whether this is going to happen, so I'll give up on that. But I would prefer that we actually go on record as approving these if we like them. And some of the changes that I think I mentioned the last time have been made, so I'm happy with that. So I'll move to approve these if the discussion's over.
There is a motion. Is there a second?
Second.
Motion and a second. Any further discussion? If not, all those in favor say aye. Aye. Opposed? Abstention. Motion carried. Thank you, Paul. Robert?
Mr. Chair, I while we're in this subject, I had brought up 2 or 3 meetings ago a request that all members of the Committee of Bar Examiners who have not had an opportunity to participate in moral character interviews be given that chance to do so that everybody would be familiar with what we're doing and in the future what we may not be doing. But that never happened. And Tara, when we talked about it, I think you told me that you had been directed not to go in that direction and just use people that had done it before. But I'm going to say again, I would like everybody on the Committee of Bar, because it hasn't happened yet, I would like everyone who has not participated in those examinations to get an opportunity to do it. I mean, that is, as of today, one of the things we do, probably the reason that I got on this committee to participate in those meetings. And I know there are a number of members who haven't done it yet. So, well, I don't know, Tara, what about that?
Can I just say one thing? So to have other members of the CBE would require that we reshift people onto the subcommittees. But I just want to get a sense right now, how many CBE members have not participated in an informal conference? So Paul, Angeli, Judy, and Kareem, and Jim. So we have 6. Okay, 6. I just want to get a sense. The other issue is this, that we're waiting for the Supreme Court to approve, hopefully, the rules, so that I think it will be challenging for us to be able to meet your request, Robbie, because the issue is that once that gets approved, it moves to the staff. We have talked about the option within the new policy, if somebody brings an appeal to the CBE, in some instances, there might be a need for another informal conference, but we're not anticipating that many. So I think probably what we could do is have members, our subcommittee list is going to be revised with our new members by the next meeting. October is usually when our new members come and we do our orientation, is putting these 6 members onto the moral character subcommittee.
I thought and I agree that once the transition is made, that I'm not talking about that. I'm talking about now while we're still doing it. I thought we had decided that Desti had said that anyone, whether you're on that or not, could participate in that subcommittee for purposes of participating in the meetings, whether you're on it, on the list or not.
Yeah, it says it a different way. It says that other committee members, if necessary, can undertake that role of being the appellate panel. So it's really just a matter of scheduling and spreading the.
It's a matter of it. They're not. No one. They have not even been invited by Tara and Mark, who do the scheduling. And even when we do the transition, I think it's important for these members to know hands-on what I would imagine everyone that raised their hand would want to do it. To see what those meetings are like. I think it'll give all of us a good perspective when we are asked to be a review body, which I think is what's coming next. And maybe, Tara, do you want to say what? Because we had talked about this 2 meetings ago. Why didn't we do it?
I think at that point, that was a discussion that I had with Amy and Mark, and part of it was we're waiting for this change from the Supreme Court. It was sent back then, and it's just been something that's kind of looming over us at this point. I think there was the training aspect. We were worried about introducing new members for maybe just one informal conference.
Yes.
Will it be permissible for observers to sit in once it switches over to staff?
Yeah, that was going to be my question to Dusty. So even once it switches over, because I think that's what you're trying to get to, Robbie, can we have a CBE member, participate as an observer at these sessions so that they get that experience? And I think we could talk about that and explore that option.
Right.
I don't know if there's a rule about that. I think that we limit the number of participants even now. You don't want it to be so overbearing for an applicant who's come to state their case with, a dozen people staring them down. I think we've been limiting it to 2 or 3 people in the room plus the coordinator, which would be you. But I really think before that transition is finalized, even if it's just one more, probably the next round of interviews, it looks like the people that raised their hands are split between North and South. I really would like everyone to have a chance to do it and maybe come 15 minutes, 30 minutes early to get a little bit of introduction from a lead person, whether it's Tara or someone that's done it before. But I think that would be very valuable, especially if we're reviewing in the future this is what the meetings are like. This is what how the applicants are questioned. As I said, I thought we had decided a couple meetings ago that that's exactly what we would at least invite them. And Tara, we have not. We've only invited the members of the subcommittee who have been doing it all year.
Yeah, I think we could try to accommodate that. I don't know when our next meetings are scheduled, but I'll follow up with Tara.
Okay, thanks.
Okay. The next item is a discussion of the moral character goals and accomplishments. Jen?
Yes, so item O, open 501 lists the moral character determination goals and accomplishments. Again, our second working group meeting is going to be next Wednesday in LA. It is an open meeting if anybody wants to attend. And we have 2 upcoming presentations which I think would be helpful. One is Dynamics of Sexual Assault and Survivor Response. That hopefully will be in December with the full committee. And then October, which I guess is next month in LA, we're going to have a presentation on implied bias, or at least we're going to try to. So that's all I have to report now, unless someone has questions or want to make modifications of our goals and accomplishments.
Jim?
Yes.
You said there was a meeting in LA. Do you have the date?
Well, the next Wednesday is the working committee meeting.
Which is the one that you invited us to?
Well, you're invited Okay, the working committee is an open meeting. Anyone can come, if I'm correct, anybody can come to a working committee meeting next Wednesday. It starts at 10 in the morning, goes till, I think, 3 or 3:30 in the afternoon.
And it'll be at the Los Angeles office.
Los Angeles office.
Which one do you recommend we attend? Is that open for?
Well, you can
Servers?
watch that meeting, I think it's televised if you want to
Oh,
watch
okay.
it. Which is what Robbie was talking about, is he wanted to see, at some point in time, the things we're going to talk about on Wednesday, if they could be available ahead of time, that'd be great. If not, then at least they can be available later, so you can kind of watch the video later and say, oh, this is what they're talking about, and comment on that. And then the October meeting is the full committee meeting in Los Angeles, as I recall, which we need you to come to.
Thank you. I appreciate it.
Okay, Alex still has not arrived, so we're going to take about a 10-minute recess now.
Mr. Chair, in his absence, I am prepared to fill in, but I'm also game for a break if we...
Why don't we take a 10-minute
Okay.
recess? Please reconvene at 5:02.
Was the Glitch and Ames responsible for some of those things I read?
The next item on our agenda is under educational standards. Alex's flight had been delayed, and so he said, I just talked to him on the phone, he said that it would be another 30 or 40 minutes, and so we're going to go ahead and proceed. Kareem and Natalie, you want to lead off, please, with the request for major change?
Certainly, Mr. Chair. I'll wait for everyone to get back to their seats for another 2 seconds. 1, 2. All right, we're there.
Do you want to invite Dean Weimer up in case there are any questions?
Oh, yeah, I'd like to invite the dean from San Francisco Law School, which is Alliant, right? Yeah, Alliant, if you want to come up. All right, well, thank you all. Thank you for being here. So open item 0400s on the major change for a campus move. So Alliant University has filed a major change request seeking permission to move their San Francisco Law School from its current location to a new location effective November 4th, 2019. It's seeking to move from its current location on One Beach Street in San Francisco to a proposed site approximately 12 miles away at the Emory Tech Center in Emeryville, California, effective November 4th. The school currently shares space with Alliant University's other programs and would continue to do so in the proposed new space as well. And as a reminder, an accredited law school must request and obtain the prior approval of the committee, bar examiners, by filing a major change request, which we have before us under accredited rule 4.164. The school provided the attached major change request and was forthcoming with information. And as a part of the preparation, staff reviewed the copy of the application to seek permission to move that Alliant University has also filed with the Western Association of Schools and Colleges, addressing all programs offered by Alliant University in the San Francisco Bay Area. WASC has provided permission, given permission for the move to obtain approval, and that leads us to the recommendation. So the recommendation of the committee is that the committee approve the move of San Francisco Law School in concert with the rest of the Alliant University's San Francisco campus to Emeryville, which would be effective November 4th, 2019, or soon thereafter, allowing for minor contingencies for timing and planning. So the school is advised to continue to monitor the timeline for the move, making adjustments as needed to support effective student learning. If there's any questions, we do have the applicant here, and we also have staff on hand.
So moved. Motion, is there a second? Second. Motion and a second. Any further discussion? All in favor, say aye.
Aye.
Aye. Opposed? Any abstentions? Motion carries. Thank you very much.
All right, thank you. That was very quick.
It was.
All righty. So our next item is going to be open item 401, which is a decision on the Santa Barbara and Ventura Colleges of Law waiver to teach courses off campus. So Santa Barbara and
Would you like to invite up Dean Gartina?
oh, Dean Gar. Hey, how are you? Long time no see. So Santa Barbara and Ventura Colleges of Law filed this major change request seeking approval and ratification of its emergency one-time decision to teach courses for the purposes of assisting students at the Western State College of Law to further their progress towards their JD degrees. And in background as well, an accredited law school must file a major change request under Rule 4.164 when sponsoring or offering law study credit. Any individual seminar or class that will meet more than 55 miles from the law school's principal facility or outside of California. So the school is teaching courses more than 55 miles away from the campus on a one-time emergency basis during the summer of 2019. Typically, a request like this is submitted in advance of offering the course, but these are particular circumstances. Therefore, the Western States College of Law has been operating under the control of a federal receiver, and its future, as we all know, is uncertain for the forthcoming months. So Santa Barbara Ventura College of Law sought to help students at Western State College of Law as part of its mission. So they've hired Western's faculty to teach courses and use the school syllabi to teach the courses, making sure that the courses are compiled within the rules and the guidelines. So the recommendation. Give me 1 second to find the recommendation.
It's on page 2. I'll also move, the recommendation is to approve the major change request.
Second?
Motion and a second. Any questions or discussion? If not, all in favor say aye.
Aye.
Opposed? Are there any abstentions? Thank you very much.
Thank you. All right, thank you for that. Next item is item 402, right? Which actually has been withdrawn, so that will be, staff, do you have anything in regards to that, or?
We'll take up that item in October. It was withdrawn at the request of the school, who will be providing further clarification for the committee.
All right, so that brings us to open item 403, which is the report on the minimum cumulative bar passage rates for California accredited law schools. I discussed this earlier in my CS Bars report, and just as a reminder, California accredited law schools must maintain a 5-year minimum cumulative bar passage rate of 40% or greater under Rule 4.160 and Guideline 12.1. So all 15 CALs have reported their 2019 NPRs, and 2 schools did not meet the 40 percentile. So I'll have staff provide us some follow-up that is needed.
Sure. So with respect to those schools, just generally, we normally post the NPRs for all of the schools on the website, so we're looking for your approval to do that. And then with respect to the schools that did not meet the 40% minimum, regrettably, they did not meet that minimum last year either. And so this committee began the notice of noncompliance process, and we have requested in the motion permission to continue with that process in the form of an inspection, bringing back the results to the committee in concert with the written statements from those schools. And the committee can use that data to determine whether probation or termination of accreditation is appropriate for those 2 schools. And just for a historical purpose, those schools have been under the 40% minimum since at least 2014.
Are there any questions? Yes, Larry.
Pacific Coast University School of Law and the Southern California Institute of Law.
And Jim, if I might note, this requirement for an inspection for schools that are in noncompliance doesn't frankly make a lot of sense when the noncompliance has to do with failure to meet the NPR. And so this is one of the things that will be teed up for the thorough review of the rules and guidelines that we'll be doing through and with the assistance of CS Bars to look at accreditation processes and what is it that we are actually looking for when we do accreditation and how we should follow up on these issues of noncompliance, because doesn't make a lot of sense, but it's currently what the guidelines require.
And so to clarify, that's also why staff is recommending a telephonic inspection, because you're not looking at the physicality of the campus, something you'll see when you're there. It can be conducted over phone, conserving state bar resources and conserving school resources.
Are there any questions? What's the pleasure of the committee?
So, do you want me to review the recommendation, or?
It's before the committee in the written form, so.
Your Honor, you've just been elevated. I will move with respect to the proposed motion.
Second?
Motion and a second to approve the recommendation of staff. Any further discussion? All those in favor, say aye.
Aye.
Opposed? Any abstentions? Okay, motion carries. Thank you.
All right, thank you for that. Next is open item 404, which is a notice of new administrators and registered and accredited law schools. And the following California accredited law schools have notified the Committee of Bar Examiners of the following changes to their respective administrative personnel. So John F. Kennedy University School of Law has named acting dean Lisa Hutton. Trinity Law School has named interim dean Myron Steves. And then the following unaccredited law schools have notified the committee of the following changes to their respective administrative personnel. California Southern University School of Law has named interim dean Ellie Sheffy. People's College of Law has named registrar Brian Godfrey. California Desert Trial Academy College of Law has changed the name of its corporate ownership entity from Law Talk MCLE Incorporated to CDTA College of Law Incorporated, but the structure, ownership, and ID numbers for the corporate ownership remain the same, and the law school's name will remain the same.
Okay.
So if there's
That's for information only, so there's no action required of the committee. And finally, a discussion of the educational standards, goals, and accomplishments.
Okay, that brings us to 405. So what we're looking as our existing standards and goals and accomplishments. I'm looking for feedback on goals from the group. And I do want to acknowledge that there are 2 items that have been completed in the goals, and staff will provide some additional background as to those items. And then number 3 is a draft, and for number 3, there's going to be a draft introduced at the October CBE meeting.
Sure. Okay, thanks, Kareem. So the focus this year has been on reviewing and clarifying the rules, and I just wanted to confirm, as described in the goals, that per this committee's direction, the applications for accreditation for online JD programs have been released. We're beginning to receive part of the materials. You may see those applications as soon as October. Also, accredited schools are filing major change requests to expand their online offerings. And we've been getting positive feedback about the Dean's e-newsletter. We will continue to work on the rules changes, as Kareem mentioned, to bring some back to you in October.
So is there anything from the group that would like to include into the educational goals, or if not, then I guess we close the discussion. And
I don't think any further action is required, so thank you very much. It's
Thank you, Mr. Chair.
There are no changes. Okay, I believe that concludes our open session agenda, and so we will be convening in closed session. Thank you very much for attending. Time. Item C, which is recognition of outgoing officer and members, attachment 0-100. And I will defer to Amy.
Yes. So we have a few citations to present to some of our outgoing members. Again, we have not heard back about new appointments, and so as we do, then we will keep the CBE up to date and informed on those decisions and the impact that it might have on the committee. But in the meanwhile, we want to recognize our outgoing officers, and to start, we'd like to recognize Jim Fox for his leadership as chair this year, and for his service to the legal profession in California in general. Jim will continue on board as a CBE member for 2 more years. So thank you, Jim. Thank you. Next, we have a citation for David Torres, thanking him for his commitment for 4 years on the CBE and for his work in the legal profession in California. So thank you, David. Our next one goes to Judy Gillespie for her year of service here. Sorry, the last one. Dolores Heisinger. She is terming off. Unfortunately, she couldn't be with us today, but we are going to try to present this to her at the October meeting. So 1 more to go. All right. So the next agenda item is recognition for our retiring staff members. So the first is for Tedeschi. We want to thank you so much for your service here as our council. I wish you the best in your retirement, Tedeschi. Thank you. To say something, Robbie, you had something also?
I wanted to say first for myself, when I got on the Committee of Bar Examiners and looked at the agenda for my first meeting, I thought the idea of hearing about litigation that went way before me sounded so boring and awful that I was dreading that. And working with Dusty and listening to it turned out to be the best part of every meeting for me. Dusty, you've been so awesome, not only as a friend, but as a presenter to the CBE and making everybody feel a part of things that are going on with the bar. It's just been awesome. And on behalf of a couple of the members, David, myself, Alex Chad, Brody, and Jim Efting. I just want to, I'm not leaving.
The puppy needed a good home.
Oh, very sweet.
From downstairs, because you're so awesome. So congrats.
That's beautiful.
Here's the one on the end.
I know.
Pretty, right?
I'm not questioning.
Thank you. From
And we object to your
You
retirement.
have us?
Yes.
All right. And then one more. As many have heard, Mark Torres-Gill is retiring on October 1st. So I want to personally thank him for his work. He's been assistant director since December 2018, and I've really appreciated his dedication in that short tenure. And also, he was with the bar for 29 years. So I want to thank you for your years of service here and for what you've done to the field, to the legal profession. So thank you so much, Mark.
Okay, I think that has completed all of the open agenda items, so we're going back into closed session now. So Tom, just give me the sign when we're ready.